Happy to do that. Happy to do that. Now, today I'm going to be talking about a couple of things. I guess the primary topic, if you like, is your website, whether that can get you into trouble. I'll also be talking about a couple of the practice directions, the chairperson's practice directions in NCAT at the end of this presentation. I do have some holiday snaps which I was going to show you. I haven't had time to get them uploaded though, so maybe next time I'll regale you with what I did on my holidays. But to more serious things, can you be sued because of your website? Well, this topic draws on it's a 2018 case from Victoria, but I think it is relevant, particularly given that you guys are in a competitive market. And when I say guys, I'm including girls in that. That's the vernacular. It's a competitive market. So advertising is certainly important. And there's always the temptation to maybe over-egg the pudding a little bit in your advertising and including your website. I don't know the statistics. You guys can probably tell me the statistics better than I would have any knowledge of, is how much work comes to you through your website. Is that your most effective piece of marketing? Is it referrals or otherwise? I would imagine that your website is a very important piece of your marketing. So that's where your clients are coming from. They're reading your website, and if they're choosing you, and they've come via that means, it's because they like what they saw on the website. That's what's persuaded them to come and use your services. So it is important to make sure that that piece of advertising doesn't get you into trouble. So I'll talk about the issues, what the ruling was and the implications of the ruling. So as I've been saying, essentially, everybody expects when you're advertising that you're going to put your best foot forward, but there's a difference between basically saying how good I am and maybe going a bit too far and claiming things that aren't necessarily correct. But where does that then intersect with your report? I mean, I would hope that in your reports you have a disclaimer, you have limitations which say, for example, we're going to comply with the standard. The standard doesn't require us to inspect areas that aren't accessible. If it's more than 3.6 metres high, we don't do that, etc. So if your website's saying one thing and your report's saying another, which prevails? Where does that stand? What's the intersection? So that's one of the things that this case illustrates. So what happened in Garrett and Elm House? Fairly typical, I suppose, scenario. Pre-purchase building and pest report. It was a 100-year-old timber structure house. Certainly the purchasers were going to do some renovations, but they wanted to know what they were getting, as it were. They went to this guy Ford was the actual inspector. Like most businesses in this industry, it's actually the owner of the business is actually a company. You set it up for your tax, etc., liability structures. $500 was the cost of the report. It was a structure and pest report, a building and pest report. It was usual story, done prior to the contract actually being signed, but only a few days before. A lot of times in New South Wales, of course, the clients will sign the contract. There's a cooling off period. You guys get called in at short notice to do your inspection report between cooling off and the time when the contract's got to be actually confirmed. Mr. Ford said there was no termites, no particular structural issues. He did say, look, the floor slopes a little bit. That might be an issue, but that was about where it got to. Again, typical scenario, after the purchasers moved in, bought the place, they found termites and they found some structural problems. They got another inspector to go in who did an invasive inspection, and long and the short of it was that he recommended that the place needs to be demolished and rebuilt. It's pointless trying to renovate it, to reinstate it. So purchasers are furious, of course. They sue both Mr. Ford and Elm House. So what do they say? They said when the reason that we retained you as opposed to any other pre-purchase inspector is because of what we saw on your website. What do we particularly like on your website? We like the fact that you said that you're going to road test the house. You'll find all the hidden problems, all the hidden defects, and you've had so much experience, and you use the latest technology. So that's why we came to you. And when we got your report was inaccurate because your report said no structural issues, no termites. In fact, there were. So you have misled us, and that means that you haven't undertaken your job with due care and skill. Australian consumer law says exactly that. You've got to undertake, if you're retained to provide services, they've got to be rendered with due care and skill, and you can't contract out of that. Section 18 of the Australian Consumer Law says you can't engage in misleading and deceptive conduct in relation to trade and commerce, and obviously providing a report in return for being paid is in trade and commerce. So they said you've breached those bits of the law because there were termites, there were major structural issues, and you didn't reveal these hidden problems, and you just went out there, you had a look, you might have used a moisture meter, but that's not a high level of technology. That's just typical. It's not more than anybody else uses. So you owe us the cost of doing the repairs or reconstruction, which was about $330,000 it was estimated at. The purchase price of the house was 114 or thereabouts. So what did the VCAT say? Well, they looked at the report. The report had the usual disclaimers. It was meant to be in accordance with the standard. So if you can't access, don't have to inspect, etc., etc. However, the website was different, and the member determined that the representations in the website were that the report would identify any hidden problems and that a high level of technology would be used. And that's the reason for using Elm House and Mr. Ford as opposed to somebody else. And that was something that the purchasers relied upon when, in fact, Mr. Ford and Elm House had no reasonable grounds for making those representations, because he always knew that he was going to give a report that had the limitations and the disclaimers, and he wasn't going to go into hidden areas. He wasn't going to find all the hidden defects. And he wasn't going to be using any high level of technology out of the ordinary. So that was misleading and deceptive. However, in terms of what the actual report said, the report, with all the disclaimers and limitations and exclusions of liability, merely said that he didn't see any termites in areas that could be accessed, and that his report and his inspection was limited to accessible areas, and there were no termites in that area. And that was true. There was nothing misleading about that statement. So far as the structural defects are concerned, he made comments on various aspects, but again, the inspection was limited. It was a visual inspection only, and it was only for areas that he was able to access. So ultimately, the orders that VCAT made were that, yes, you've suffered loss and damage because you relied on those representations on the website, and that's why you went to him. But all you get as a result of that is a refund of your $500 that you've paid for the report, because you could have gone to, if you hadn't gone to him, you would have gone to somebody else. So you haven't got what you bargained for from him. You paid $500 for the report, that's all you get back. Coincidentally, because although the website belongs to the company, because Mr. Ford was the sole director of the company, he was knowingly concerned in the representations that were made by the company, therefore he was personally liable as well. And you might think $500, well, who cares? Importantly, the tribunal said that the purchasers haven't really suffered any loss and damage in purchasing the property, because before you finally signed the contract, you had his report. His report clearly contained limitations. What was in the report was accurate. As all know, the court system, how long it takes, how expensive it is, how much of a distraction it is from your business. What about your reputation? It's out there. It's a public judgment. I'm also not sure whether this would have been covered by, assuming he had it, and remember that he represented himself. If he had insurance, whether that would have covered this loss, and in particular, if he had lawyers, the cost of having a lawyer, because if the court at the end of the day has had to deal with both the website representations or misrepresentations and the negligence in the report, well, only part of those costs relate to what would ordinarily be covered by your insurance. So that could be a significant cost as well. The other thing that it highlights is how important your limitations and exclusions and disclaimers are in your report. I know I've banged on about this a few times, but it is very, very important to make sure that you need to have them in your report. If you're actually signing up a contract before you provide the report, well, you need to make sure they're in there as well, so that the consumer can't say, well, I didn't know. It's there up front before you've even provided the report, the limitations and the exclusions. So that's a salutary lesson. I'm sure you guys don't over-egg the pudding, but just a word of warning that it's important to be accurate and truthful and not go too far with your advertising dollar. Is there any questions about that particular matter?
I think what highlights for me is if he was insured, if he had VI insurance, he's obliged to notify his insurance company, so he would have been represented by them probably anyway. So more than likely he did. But I would have been curious to see what NCAT mentioned about the fact that an invasive inspection was done after purchase, which uncovered all the stuff.
What VCAT said was it's apples and oranges. Mr. Ford was never going to do an invasive inspection. The subsequent inspector did an invasive inspection, which is how they found the termites and various structural issues. So you couldn't say that just because that subsequent expert found all these things that Mr. Ford had done anything wrong in providing his report, because his report was an Australian standards report. It wasn't a compliance report, and it did everything that it was required to do, absent the representations on the website.
But how does that relate? When you look at the Trade Practices Act, it says one thing in his website, but it's done something different.
Yeah. And that, Nick, is the issue. What is the loss that arises because he's done that? Is the loss the whole of the cost of rectification, or is it just the wasted cost of the pre-purchase inspection report? Now, VCAT said, okay, what you have been misled into doing what? You've been misled into retaining this guy. But that's all that the website has misled you into doing, because when you got the report, you knew that it wasn't looking at all the hidden dangers. So at that point, you could have done something else. And so that's where the chain of causation was broken. That's what VCAT said. I think there are arguments around that, particularly given the usual timing of these things, where it's a matter of urgency. You've only got a few days as a purchaser to make up your mind as to whether or not you're going to go ahead and purchase. Do you have time to go and get another report? Are you going to lose the property? What's the practical consideration? Plus, you're talking about consumers. And I think an argument could have been made that the consumer, even though the disclaimers might have been in the report, if the consumer didn't read the report closely, only went to the summary, which said, oh no, in summary, it's typical for its age, there's no obvious structural defects and there's no evidence of termites, and the consumer otherwise relied on what was in the website, which was, oh, well, any hidden defects, they're going to be in the summary, I think a lawyer could make a good argument that in fact the disclaimers and the exclusions were ineffective unless there was evidence that the purchasers had actually read those disclaimers and understood the disclaimers and exclusions. So, skating on thin ice a bit. And I think the inspector was a bit lucky that the consumers represented themselves and didn't have a lawyer. Yep. Sorry.
On the technology side,
yes.
The thermal cameras will pick up a termite nest, but won't pick up individual termites.
Mm-hmm.
The moisture meters will pick up the termite workings with the muddings,
Mm-hmm.
right? And then the motion meters will pick up the motions of individual termites, but nothing will pick up previous damage. So if there's been termites in the house the week that plays out, then they've died and it's dried out. There's nothing out there that will pick up previous damage in the walls without more invasive inspection, which basically pull wall linings off the wall. All the reports say a more invasive inspection is required, and then when you say we're going to start pulling wall linings off, it never happens.
No, of course
so
not.
Previous damage has dried out. There's nothing out there. There's no technology to pick up that. You need X-ray cameras, and they're just too expensive and too bulky.
Yeah.
A lot of my problems is going out. People do rectification work, put a new bathroom in, find previous damage. We're going to sue.
Yeah. And the $64 question always is, was that damage apparent at the time the initial report was done and within the limitations of the initial report, or was it not? And that's
the problem I get in my industry. You guys rely on the technology. The old guys like us rely on tapping on the walls and looking with a torch.
Yeah.
And I've never found termites with the new technology first. I've always found them the old-fashioned
the old way.
Yeah.
Okay, so moving on to the procedural directions. So this comes from John Cunniff. Let me know that there were a couple of questions from members of the society about the procedural directions. 3 is the general expert evidence direction, and 7 is the AI procedural direction. So I've just these are the and the particular question about the expert evidence direction is in relation to costing. So you find there are defects, the rectification's required. It's then a case of costing that rectification. Now, what the direction says, as you see up there, relevantly, and sorry, just to follow on from that, and the other part of the question is, okay, so how are you going to do the costings? If you get a QS to do the costing for you, can you just adopt those costings? Is that permissible? So the relevant parts of the procedural direction are what I think, what I've put up there. So if something falls outside your field of expertise, you've got to say that in your report. So if doing the costings is outside your area of expertise, you've got to identify that. If you've got a QS to do it for you, then you've got to identify that fact. You've got to identify what material the QS has provided to you in order for you to put the ultimate opinion in your report. Similarly, whatever the QS has done, including their qualifications, you've got to set that out, and you've got to identify who it was and exactly which are the QS's opinions and which are your opinions. And this all goes back to the requirement in 24A that if rectification is required in your expert report, you've got to identify the likely costs involved. So I guess the short answer from that is yes, you can go to a QS if you don't feel qualified or you don't have time or whatever to do the costing. You can go to a QS, and as long as you identify the fact that you've done that and exactly what the QS has provided and the basis for that QS's opinion, that will satisfy 24A. However, from my view as a lawyer, that's all very well But the opinion that's being expressed by the QS is not your opinion. Yes, you're saying, okay, the costings I've put down here are based on that QS's opinion, but it's not your opinion, it's the QS's opinion. And if I was the lawyer acting for the other side and I got an expert report that attached a QS report and did all these things, identified it, I would be objecting to that on the basis that it's not your opinion about the costings, it's the QS's, and I need to be able to cross-examine the QS about the basis of the QS's opinion. So you might include the QS's report in yours, but if you're actually going to get to the tribunal, that QS is going to need to come along and answer questions. So I think it is very unsafe to merely annex that opinion, comply with all these things, but without being able to make the QS available to be cross-examined, you run the risk that the tribunal will exclude that part of your expert evidence. Because your expert opinion has to be your opinion so that you can be questioned about it. Otherwise, it's unfair to the other side. And if the other side does a similar thing but brings the QS along, then it's more likely that the tribunal is going to accept what that QS says, unless the QS is completely destroyed in cross-examination, than your side, because I haven't had the opportunity to ask the relevant questions of your QS where there is any inconsistency between the two opinions. So yes, you can do it, but you've got to be careful about it and make sure that there's that opportunity for the other side to cross-examine the QS.
Isn't the QS though costing of scope of work, not really giving an opinion? He's only costing what your scope of work is.
Well, it's his opinion as to what the cost of your scope of works is. That's his opinion. Otherwise, do it yourself. Why are you getting somebody else to do it? Remember that...
The scope of works puts out a method.
Yep.
Methodology on how it's going to be done.
Mm-hmm.
All he's doing is saying, well, I need 10 glasses, so 10 glasses will cost $5.
Well, what's the basis of it costing $5? Why is it going to cost $5?
But he would have
Well, he's giving an expert opinion as to what the market is. Because an expert opinion is not admissible, an opinion is not admissible unless it requires some expertise that the court doesn't have or the tribunal doesn't have. Sorry? You can use Cordell's and you can say in your report, I'm an experienced building consultant. In my experience, this is what's in Cordell's, which is a well-known publication, provides an accurate estimate of the costs of building work, and therefore I have used Cordell's to cost my scope of works.
But the downside of using Cordell's or Rawlinson's is that they are basically for new build, not for remedial work.
Well, which is the basis of cross-examination on and trying to attack your costings if they're simply based on Cordell. So your expert opinion is that in your experience, what Cordell's or Rawlinson says is an accurate estimate of the costs. So that's your expert opinion about the ability to use that material. That expert opinion can be attacked on the basis that, well, no, it's not accurate because it's only new build, it's not rectification, et cetera, et cetera. If you are getting a QS and the QS does exactly the same thing, well, I need to be able to cross-examine the QS as to why the QS thinks that Rawlinson's and Cordell's is the appropriate method to cost this scope of works. So that's the issue.
So the proviso is if the QS comes on board as an expert consultant, then and he's available, then...
He needs to be available, yes.
Well, you wouldn't bring him on unless he was available.
Yeah, well, yes, that's right. Best practice.
I think, like, where that liability lays, whether it's Rawlinson or QS, comes down to who's provided the bill of quantities. And I think that might have been what you were alluding to there before about what is the scope. Because, like, the level of definition, whether it stays at a demolition or whether the demolition includes A, B, C, D,
there is no opinion. As far as I'm concerned, there is no opinion. It's purely costing. There's no opinion.
Is not the whole point of this trying to give the tribunal help in understanding the weight that he or she is going to give to this evidence?
Well, yes, it is. Remembering that the tribunal isn't bound by the rules of evidence, but it is bound by the rules of fairness, and the tribunal can take into account and give appropriate weight to whatever the evidence is, or whatever the evidence is that's put before the tribunal. So yes. But I think the last time I was here, I was talking about whether an expert report is actually inadmissible because it doesn't follow the expert code of conduct. And what I said was that in fact the law is, at least in courts, which are bound by the law of evidence, that merely because an expert report doesn't follow the expert witness code of conduct, that doesn't make it inadmissible, notwithstanding, because procedural directions and the practice notes and the CPR, the civil procedural rules, don't override the legislation, the law. And the law is that as long as what the opinion that is being given by an expert and it's in a field of expertise, then it's admissible. It's a question of what weight is given to the report. If it doesn't follow the expert witness code of conduct, then the judge is probably going to give it no weight whatsoever. The tribunal is different because the tribunal expressly, at least in building cases, isn't bound by the rules of evidence. So the tribunal, if it wanted to, could say, well, we have our own procedures, and if your expert report doesn't follow procedural direction 3, I'm just going to disregard it altogether. In this case, what I'm saying is you run the risk of, yes, the member may say, well, I'm going to give, because you've used a QS and there isn't the opportunity for the other side to cross-examine the QS, I am going to give that part of your report little weight compared to the opposition expert's report. Just as easily, the tribunal member could say, I'm not going to admit that part of your report, your costings, because the QS is not here to answer questions. It's a risk you run. So that's 3. Procedural direction 7 is the AI procedural direction. I haven't extracted the whole thing. It's quite, there it is. It's about 6 pages long and fairly dense. This procedural direction is referred to in procedural direction 3, the expert report one, because the expert report direction says you must also comply with procedural direction 7 in relation to the use of AI. Now,
Sorry, you ask AI to summarise it for you?
have a look at the bottom. So I think the important parts of the AI procedural direction are, firstly, the bits that identify exactly what Gen AI is, because it's not every piece of AI. I mean, your word processing, which corrects your spelling, is AI. But you're obviously allowed to use that. And the other part is that the fact that use of AI, generative AI, is prohibited without the leave of the tribunal. So just looking at these ones, so 6 is important because that's where it tells you, well, 2 and 6 are important because they're the definitions, and 6 in particular, what isn't Gen AI. So you can continue to use your word processing software, your search engines, etc., as long as it's not actually making up, and I mean, I'm using those words deliberately, making up the text of your opinion. Remember also, when you're using those AI tools like ChatGPT, etc., particularly if you're using the free version, it's open. And the way that AI works is it goes around, it scrapes off public websites information, and that includes the information that it actually generates. So you've got to be careful that there's no confidential information you're putting in to your question that is then going to be available basically publicly. So if you go in and you name the parties and identify the property and so on, that's going to be out there in the public domain. And so particularly if you're breaching privacy laws and so on, you can't do that, and you ought not to do that, whether or not that's in the procedural direction. So that's just a general word of warning. But as you see in 11, you can use Gen AI for administrative and preparatory purposes, like chronologies, drafting arguments, but it's got to be your opinion. And that's fleshed out further in 12, which is a general prohibition on using Gen AI to generate your statements, your affidavits, basically your expert report. And 20 is the express one. You can't use Gen AI to draft or prepare your expert reports without leave from the tribunal, subject to those exceptions that we were talking about earlier, so your word processing and so on. When you're applying for leave, you've got to identify what you're using, why you're using it, why you need to use it, basically. And then in your report, again, you've got to disclose that you've used Gen AI, which one you've used, what questions you've asked it, so that the tribunal and the other side knows which parts of your report are expressly your opinion and which parts of your report have been the product of AI. Again, on the basis that leaves those parts of it open to questions, to cross-examination about whether you've used the right question. Sorry, Penny. Yeah, if that's all you've used it for, then yeah, there's no harm in doing that. It basically avoids a question at the beginning of the cross-examination: have you used Gen AI in this at all? Yeah. So yes, that's helpful. So that's the 3 and 7. Okay. All right. Well, thank you, gentlemen. I was asked earlier whether in my 4.5 weeks away I'd thought about a story to tell you. As briefly as I can, yeah. Look, so some of the things we did on my holiday were to go to a few restaurants and bars and eat too much and drink too much, and some fantastic places, quite spectacular locations. But it put me in mind of a story about a guy at a bar. There's a younger guy sitting at the bar, minding his own business, having a drink, and this older guy kind of stumbles up to him from the other end of the bar, nudges him and says, "Hey, I've had sex with your mother." And the younger guy just doesn't rise to the bait, just kind of turns his shoulder a bit, ignores him. The older guy stumbles back down to the other end of the bar. 5 minutes later, the older guy's back, nudges him again, says, "I've had sex with your mother and she liked it." The young guy still doesn't rise to the bait, still trying to ignore him. The older guy wanders back down to the other end of the bar. 5 minutes later, he's back again, nudges the guy, says, "I've had sex with your mother, she liked it, and I'm going to do it again." And finally, the younger guy reacts and turns around to him and says, "Dad, you're drunk, go home."